Good morning, Mr Mitchell.
Good morning, my
Ms.
lord.
Graham.
Thank you. Good morning again,
morning.
Mr Mitchell.
Good morning.
You were last here at the end of February,
Yes,
and I want to carry on
Yep.
with the questions that we started.
I understand.
There was one thing I'd like to clear up at the outset, and that was about the timing of your move to Director of Operations. So you were Director of the Investigations Team, and you explained last time you'd moved to a new role, Director of Operations.
Yes.
And I wondered if you may have been slightly mistaken about the date, and I'll tell you why. The inquiry have been told by Michelle McLeod, Commissioner, that you moved and became Director of Operations in August 2016.
Okay,
Would that...
Yes.
I think you'd said you thought maybe March, April.
Yes, and I think I thought originally 17. I've tried my hardest to get my head round that one, but if they say that it was the 16th, that will be absolutely right. Of August, that'll be correct.
The reason I wanted to clear that up is because, am I right in thinking your move to become Director of Operations took place after the submission of the final PIRC report, or not? We've heard that the final PIRC report was sent to Crown Office in August 2016, and I'm just wondering about the timing of your move in relation to that report.
See, I recall quite clearly the interim report being...
And that was August 2015,
Yes.
I think we've heard.
But I'm not so sure about the timing of the final report.
All right.
I am not, I'm afraid.
All right, thank you. When we left off last time you were here, I was going through the 5 principles
Yes.
in relation to Article 2.
Yes.
And we'd dealt with independence and adequacy to some extent, and we'd dealt with it being reasonably prompt.
Yes.
I want to move on to public scrutiny,
Yes.
which is sort of 4th principle. And I'd like to ask you some questions about media engagement.
Okay.
So we've heard evidence that the SPF issued a statement or press release on the 14th of May 2015.
Okay.
And could we look maybe at your inquiry statement, SBPI 00423, and I'm interested in paragraph 387. And when you were giving your statement, you were referred to a release by the SPF to the media on the 14th of May 2015, which contained details about the incident involving Mr. Bio, including a petite female police officer responding to a call of a man brandishing a knife was subject to a violent and unprovoked attack by a large male. The officer believed she was going to die as a result of this assault. And you've said here that that was completely unhelpful. You say, we're in the early stages of an investigation where it hasn't been determined what the facts were, and I don't think that type of release does anything but stir annoyance in some areas. That sounds as if that's an absolute fact. And I think later in your statement you describe it as not appropriate.
Yes.
Can you tell us a little bit about your concerns from the perspective of PIRC at that time, 14th of May?
Yes, I think even more generally in any investigation at its early stages, what we are trying to do is identify witnesses who can provide us with evidence that's pertinent to the investigation. I sometimes feel that a release like that would tend to suggest that we knew what had happened without any doubt whatsoever. And my fear always is that turns witnesses off. People who may believe that they have something to offer wouldn't come forward because they have this understanding that that's an absolute, and that's what occurred. So I was worried that it may deter some people from coming forward or for providing information that would otherwise be helpful.
Thank you. Did you have any concerns in relation to the family and how they would react to this type of information?
Yes, again, you know, had we known that that was going to appear in the newspapers, I think we would have had a duty to tell the family, to pre-warn them that that was going to be coming out.
Right. And in terms of having a duty to pre-warn the family, whose responsibility would that be to organise that
It would be the
contact?
it would be the senior investigating officer's responsibility, and in this set of circumstances, either he or an instruction to the flow to make contact with the single point of contact for the family and make them aware that that type of detail was going to be released into the press.
Thank you. And can I ask you to think about now paragraph 392? And this relates to a later press release from SPF, which was on the 2nd of June. And you'll see here, you've been referred to a press release issued on the 2nd of June. So this is prior to having the officer's statements, in which the legal advisor for the SPF, Peter Watson, stated, "The officers involved have never refused to provide statements. It was agreed at the outset with PIRC that they would revert to us when they wanted statements and when they were clear on the basis that statements were to be given. PIRC emailed me this morning at 10:46 a.m. asking for our assistance to organise interviews, and we answered at 11:29 a.m. confirming we would be pleased to assist. Those are the facts." And then I think we move on to 393, sorry, just below. Your response is that it was completely inaccurate. The suggestion that that was the first and only time that we had made it clear to Mr. Watson or anyone else, including the individual officers, that their position was that of witness and that we wished to take a statement from them. I'm interested in what you say here. Was it your impression that that statement from the 2nd of June was completely inaccurate?
Well, maybe if we take it from the sentence which begins, "PIRC emailed me this morning at 10:46 a.m. From there to the end, that's an accurate reflection on what happened on that day. The matter that has been suggested that there had been no attempts previously to have statements from the officers, or that there was no clear understanding that the officers were witnesses, was just inaccurate.
So the statement there, the officers involved have never refused to provide statements. What's your position in relation to that sentence?
That's not the case.
It was agreed at the outset with PIRC that they would revert to us when they wanted statements and when they were clear on the basis that statements were to be given. That sentence, what's your comments about that?
Again, that's inaccurate.
Right. Thank you. Now, we've heard that there was a response by the Commissioner to this
Yes.
comment from SPF. Could we look at 395? And this relates to the response. Here we are. A statement released by PIRC on the 4th of June. So this is 2 days later.
Yep.
The PIRC has been leading on the investigation into the death in custody of Sheku Bayo, and since the hours following his death on Sunday the 3rd of May, has made several attempts to secure statements from the arresting officers. Those officers have now agreed to provide statements to the PIRC, and now that PIRC is in the process of gathering the material, it will be considered along with the information already gathered throughout the course of the investigation to date. Did you agree with that statement issued by the Commissioner?
Yes, I agreed with the terms of the statement, yes.
Thank you. Were you part of the discussions with the Commissioner about whether or not to respond to the earlier SPF comment?
That was a decision by the Commissioner at the end of the day. She was quite exercised at the fact that that statement you have previously covered there included inaccurate information, and she felt that it was important that we responded.
And why, can you explain why the PIRC responded on the 4th of June to the statement SPF made about the timing of statements and obtaining statements, but not to the earlier statement we looked at, which was from May, about the petite female officer?
I think the rationale behind that was that was a direct attack on the Commissioner's position in relation to inaccurate information about attempts to address the non-provision of statements.
Thank you. Thinking about things now with the benefit of hindsight, and I appreciate you're retired, but do you have any views about whether, in the context of public scrutiny, matters would be improved if there were more prompt corrections of misinformation or inaccurate information, or that a more robust approach was taken to media stories by PIRC?
I always find that to be a difficult one, because I don't think that we should be playing out an investigation in the media. Now, I think it's absolutely correct that if you're looking for assistance, or you're looking to trace witnesses or positive aspects towards the investigation, that you would use the media, but to generally play out in the media and an ongoing investigation, no, I'm not necessarily in favour of that. Maybe I'm old-fashioned, but that's my opinion.
And would that be your opinion for both PIRC and any other bodies who are involved in matters in which PIRC are investigating?
Yes, I think it would be. I think it's to be reasonable in your approach.
And to what extent would that assist the investigation PIRC are carrying out, or at least not hinder the investigation?
No, well, again, it can sway certain people, is my belief, you know, that some people will want to take one view, others another view, and if they read about it in a paper, again, it might have a detrimental effect in attempting to gather evidence which may be important.
Thank you. I'd like to move on to a conversation you say you had with Callum Steele.
Yes.
Could we look at 398? I have been asked if I recall having any discussions with the SPF about this matter. I think I spoke to Callum Steele. He was either the president or the chair of the Federation. I think it was after we responded in the media, because I think that's when he phoned to the office.
Yeah, he made contact with me, that's correct.
Right. You've mentioned Callum Steele, and then you say he was either the president or the chair. How confident are you that it was Callum Steele who phoned the office?
Oh, it was definitely Callum Steele I spoke to.
Do you know Callum Steele?
Yes.
Right. Thank you. And you say he was either the president or the chair of the Federation. How confident are you about his role?
I'm not General Secretary. I'm not 100% sure of his title, to be honest.
Thank you. At 399, we can see that there. You say just the fact that that was inappropriate. He was still claiming that attempts hadn't been made. And I was saying, well, that's wrong. There were several attempts made.
That was my position.
Right. And did you maintain that position through the conversation?
Absolutely, yes.
Can we look at paragraph 401, please, which is a letter sent by Callum Steele on the 5th of June. So this is after PIRC have responded publicly in the press and after the call. Sent by Callum Steele to the Commissioner, Kate Frame, and there's a quotation from it. On the 7th of May, and following receipt of information that the officers involved were to be compelled to give statements, an email was sent to Detective Chief Inspector Hardy, in which clarification of the status of the officer's question is sought. That email is copied to John Mitchell. I am advised Mr. Mitchell subsequently confirmed by telephone that no statements could be compelled and that the status of the officers was fundamental. Now, did you know, obviously Mr. Steele here says, I am advised Mr. Mitchell, subsequently confirmed by telephone, that no statements could be compelled and the status of the officers was fundamental. Is that something that you did contact SPF about, to say that no statements could be compelled?
Well, no statements could be compelled because there was nothing in the law that would permit us to compel statements from officers. Status of the officers was fundamental. It's not really the type of language I would use.
Right. And then it says, I am also advised Mr. Mitchell himself advised that the status of the officers couldn't be confirmed until such time as the post-mortem had been carried out, and that he would clarify with Mr. Watson. We've heard that Peter Watson was the legal representative. when the position would be clarified?
No, that was Mr. Watson's perception. I made it quite clear to him that we wished to interview the officers as witnesses.
So where it says Mr. Mitchell himself advised the status of the officers couldn't be confirmed until the post-mortem had been carried out, you disagree with that?
No, and I had no contact with Peter Watson prior to the post-mortem having been carried out. The post-mortem was carried out on the 4th of May when I wasn't even in the office.
Right, thank you. And it then goes on to say he would clarify with Mr. Watson, that's you, would clarify with Mr. Watson when the position would be clarified.
The position at that stage was quite clear to me from day one that the officers were witnesses.
Right, thank you. And then it goes on to say, I'm also aware that in a number of subsequent telephone conversations, Mr. Mitchell commented that in his opinion the officers were always likely to be considered witnesses, but no written confirmation to this effect was received. Do you have any comment to make about that paragraph?
I'm sure at one stage an email was sent to Peter Watson and it was said in that email that the officers were witnesses. It's at the time when we had the officers approached directly to see whether they were prepared to give witness statements.
Can I ask, at any stage did anyone, either Mr. Watson or anyone from SPF, or indeed any of the officers, request written confirmation of their status?
Not that I recall, no.
Thank you. And at paragraph 2, you said you were asked if this matched your recollection, so the comments made by Mr. Steele in the letter, and you say absolutely not. I made it quite clear to Peter Watson that in our view at that stage, the officers were witnesses and we wished to interview them as witnesses. And when you say you made it clear to Peter Watson, how did you communicate that to Peter Watson?
Verbally on the telephone. I made it quite clear to him that they were witnesses.
When did that verbal conversation take place? Was that what we referred to earlier? Or?
I put a message in immediately after, which would be dated. I believe it may have been the first day I was in the office, because if I recollect correctly, he actually called to speak with the Commissioner, and she was unavailable and the call was put through to me.
And from memory, was that the 5th of May?
I think it would be the 5th of May, yes.
Thank you. I think you clarified that
Yeah.
was the date earlier. Can we now look at paragraph 404 of your inquiry statement? And this refers to a subsequent letter dated the 25th of June from the Commissioner, Kate Frame, to Callum Steele, in which the Commissioner refers to me speaking to Mr. Steele after his letter was received and providing clarification. Yes, I remember he was quite heated about the fact that our response in the press was inaccurate, and again I pointed out to him the various attempts that we had made to secure statements from the officers. So this is in relation to a letter sent by the Commissioner to Callum Steele,
Yes.
responding to his earlier letter we've just
Yes.
looked at. Did you assist the Commissioner in framing or drafting this letter to Callum Steele?
Well, I certainly had a discussion with the Commissioner, because I was asked how he had been on the telephone, and I gave the information that he had, well, he'd been less than pleased, and he was heated, as I say.
Right, thank you. Could we look at SPF 000205, please? And do we see here that this is the letter of the 5th of June to Kate Frame, and this is the letter from, as I understand it, at the bottom it should say Callum Steele, General Secretary.
General Secretary, yes. Okay.
So that was his role at that time.
Yes, I
Thank you.
appreciate that.
And can we then look at the response from the Commissioner, Kate Frame, which was dated the 25th of June. Now, my understanding is that this is PIRC 02150A. Here we are. And this is the letter from PIRC to Mr. Steele, 25th June 2015. Can we look at the very bottom? And it should say from Kate Frame, the Commissioner. There we are.
Yes, indeed.
And can we look at the first page, please? And there's a reference to his Mr. Steele's letter of the 5th of June, in which you seek clarification of a number of issues. And I'm aware that, I understand that immediately after emailing your letter, you contacted Mr. Mitchell to discuss matters, and I'm aware that he was able to provide the clarification you sought. And there's, in paragraph 3, it says, I'm concerned that you appear to query the accuracy of my PIRC release. I'd like to look at the start of the bullet points. She says, so that you're left in no doubt about the several attempts made by PIRC investigators to secure statements from the police officers involved. It may assist you if I provide a list of the specific attempts.
Yes.
And there are a number of bullet points. The first attempt was made on the 3rd of May, and there's an explanation given there in relation to those attempts. The second attempt was made on the 4th of May, when PIRC informed Police Scotland that the outcome of the post-mortem was inconclusive. And then the third attempt was made on the 5th of May. Professor Watson, the police officer's legal representative, was contacted. He confirmed that he had advised officers to make no comment until full details of the post-mortem results were known.
That's correct.
Was that the conversation you were referring to a moment ago?
Yes, it was.
And then the fourth attempt was made on the 6th of May, when PIRC investigation staff again requested the provision of operational statements from DCI Hardy, Police Scotland. No statements were provided.
That's correct.
We've heard evidence that DCI Hardy was instructed by Mr. McSpadden to go and speak to the officers themselves in person.
That's correct.
And he initially spoke to the majority of the officers, advised them that their status was as witness,
correct,
and invited them to provide statements.
That is the case, yes.
And all declined on the basis that they wished legal advice. Or
yes.
Did any of those officers ask for written confirmation of their status?
Not to my knowledge.
And we've heard that others were asked subsequent to that, and the position was the same. Can we move on to the next attempt, please? The fifth attempt was made on the 7th of May, when PIRC wrote to Police Scotland stating that, notwithstanding Professor Watson's advice to the officers involved in the incident, we wish to confirm the individual position of each of the officers in relation to our request for statements. This correspondence also confirmed the status of the officers as witnesses to the event, and I enclose a copy of that email for your information. In response, Police Scotland advised me that each of the officers had been contacted, their status clarified, and that they'd been asked if they were willing to provide a statement. In response, Police Scotland advised me that each of the officers did not wish to provide a statement at that time following legal advice.
That's correct.
And then on the 6th occasion, on the 2nd of June, Mr. Mitchell emailed Peter Watson directly and again reiterated his request that PIRC investigators interview the police officers involved. Again, that email confirmed that the officers were to be interviewed as witnesses. I note on this occasion the officers agreed to be interviewed. And was that the email that you were talking about?
Absolutely, yes, it
a
was.
Moment ago. Can I ask you to look at some other matters, actually? Can we look at something else from the 7th of May? PIRC 03710. Now, this should be headed up incident message from that date. And do we see there the date on the left-hand side, 7th of May, and the time is given as 11 a.m.
Yes.
And your name appears there, John Mitchell,
Yes.
D of I. And then if we look at the information provided on this sheet, can I ask you to read that out?
Yes, it says, I have spoken with Mr. Peter Watson, who acts for 9 police officers involved in the Kirkcaldy death of Sheku Amu Tejan Bayo. Mr. Watson has advised the officers not to give operational statements until their status is known. He states that this will be his position until full results of the post-mortem examination are known. I include a copy of email from Mr. Watson.
Thank you. And if we move down onto what is page 3 of the PDF, do we see that you've attached a copy of an email, and it says there, from Peter Watson, 7th of May 2015, 11:29.
Yeah.
And it says, Dear Mr. Hardy, I represent all of the police officers, 9 in number, involved in the incident in Kirkcaldy, currently being investigated by PIRC. I've been given to believe that instructions have been given by you or someone connected with this inquiry that these officers are to be told that they are compelled to provide statements. As a matter of law, that is not correct. You should seek advice on this matter. These officers enjoy the same legal rights as any member of the public. You can ask them to provide statements, but my advice is that they do not do so until their status is clarified. I have spoken with Mr. Mitchell in PIRC. He is aware of my position. The response each officer gives will be as follows. On legal advice, I decline to provide a statement at this time until my status as a witness or a suspect has been confirmed to my legal advisor, Professor Peter Watson, PBW Law.
Yes.
At this stage, can I understand your position? Had you confirmed the status of the officers as witness to the legal advisor, Professor Watson?
Yes, absolutely. On each occasion I spoke with them.
Did you understand in relation to that email that there was an expectation that this would be done in writing?
No.
Thank you. Can we now look at your inquiry statement briefly and look at paragraph 290? Perhaps we should look at 289. This is a part of your statement where you've been talking about, on the 5th of May, a telephone call received from Peter Watson. And he identified himself as acting for the officers. And you said, during the call I informed him that we were keen to get operational statements from those officers. He at that time knew the result of the initial post-mortem examination, and his position was that his advice to the officers was not to supply statements at this time. I tried to reassure him that the officers would be dealt with as witnesses, but despite that, he stuck to the line that his advice to the officers at that time was not to provide statements. Is that the call you were talking about
That's
earlier?
the one, yes.
And then at 290, you say, I spoke again with Mr. Watson a couple of days after that. That's after the 5th of May.
Yep.
I think that might have been the 7th of May. That was to inform him that despite our previous conversation, we were going to have the officers approached individually and asked if that was their position. His position still was that he advised them not to provide statements.
Absolutely.
And is that the steps that were taken in relation to the incident message we just
Yes.
looked at?
Yes.
And that was dated the 7th of May.
Yes.
Thank you. Can we look at 291 and 292? I've been referred to a note of this call with Peter Watson on the 7th of May, and that's your handwriting. And then it says, I've been referred to an email sent later on the 7th of May at 12:19 hours by Senior Investigator McSporran to DCI Keith Hardy, confirming the status of the officers was as witnesses and requesting that they provide operational statements. And was this the initial instruction from Mr. McSporran to DCI Hardy?
It was, yes.
We've heard that DCI Hardy was the single point of contact.
Yes, he was.
Was that for Police Scotland? Or was it for the officers?
It was for Police Scotland. It was to provide whatever assistance was required, maybe to receive documentation, etc., SOPs, that type of thing, so that everything would be pushed through DCI Hardy to make that a more streamlined approach.
So I'm interested in the status of DCI Hardy. Who appointed him as single point of contact?
Someone within Police Scotland.
So he's not appointed by PIRC?
No.
And can you explain, is there a difference between having a single point of contact for Police Scotland and the existence of Mr. Watson, who's representing the individual officers? Is there a distinction there between communicating with Police Scotland as opposed to communicating with the officers?
Yes, I would say so. Yes, I mean, the role that the DCI had, as I say, was to assist the investigation and providing information, copies of SOPs, the likes. I think he was probably appointed after discussion with the Professional Standards Department within Police Scotland. The situation with Mr. Watson was that he contacted me initially, and when I phoned him back on the 7th of May to say that we were going to approach the officer individually, that was a courtesy more than anything, so that was why I took that on board.
So would you normally be communicating with the lawyer representing the officers as well as the single point of contact for Police Scotland?
Well, I had no contact with the single point of contact. It was purely and simply a matter that because Peter Watson had contacted me initially, and as I say, through courtesy, and hopefully by doing so again and telling him that we understood that his position, that he was giving them advice to make no comment, I actually wanted to hear that from them. So ultimately it was a matter of courtesy.
And is that why Mr. McSporran ultimately went to DCI Hardy himself and
actually to get the action done, yes, to
officers?
get someone sent to us. I wouldn't have asked Peter Watson to do that.
Thank you. And was there any expectation on your part or on the part of PIRC that DCI Keith Hardy would be informing police officers, either individually or through Peter Watson, about steps being taken by PIRC or anything of that sort?
I had no reason to believe that DCI Hardy would do that, no.
As far as you're aware, was there any request for the status to be confirmed in writing that was drawn to your attention?
Only on the 2nd of June.
Right.
And I did that.
You did that straight away on the
Yes,
2nd
I
of June?
did.
Thank you. Can I ask you now to look at Can I ask you now to look, please, at COPFS 04609? We've heard some evidence about this, that this is handwritten minutes taken or noted by Lindsay Miller in Crown Office. And it relates to a meeting on the 14th of May. You'll see the date at the top.
Yes, I see that.
And it was a meeting with the Lord Advocate and PIRC, namely yourself and Kate Frame, the Commissioner. And it was also attended by Les Brown, who was the head of Cap D at the time, we've heard. Can I ask you to look at these minutes?
Yes.
And in particular, I'm interested, if we move down the page, first of all, you see Lord Advocate seems to open the meeting saying it's a disgrace, there's no statements provided, and they should be suspended.
Yes, he did.
Sorry?
Yes, he did. Yeah, I
And
recall
you
that.
say you didn't disagree with that.
That's correct.
Was that your mindset at the time?
It was, but again, that's a matter for Police Scotland at that stage.
Right. And then, do you see the next section? It refers to Peter Watson and confirming his advice. And it says, confirmed they're taking legal advice, the officers.
Yes.
Then further down, just below that, you see the line that's travelling down the page?
Yes, I do, yeah.
Just beneath that, there's the initials JIM, which are
Yes.
your initials. May need to detain and interview under caution. This is a carbon copy of the Duggan scenario. It looks like it says, but independent confirmation of his actions in an asterisk.
Yes, I do see that.
I'm interested in the phrase here that seems to have been attributed to yourself. May need to detain and interview under caution.
This was a general discussion around getting statements from the officers and the concerns that by the 14th of May that still hadn't been achieved. And I know there had been lots of discussion around this matter of compelling witnesses. At that stage, the IPCC, who would have taken on board the investigation into the death of Mr. Duggan, I believe, had the powers to compel officers to attend for interview. What they didn't have was the power to compel them to speak once they got there. And from memory, I think that my point was is that the closest thing that we had to that was a detention in terms of Section 14 of the Criminal Procedure Scotland Act 1995. I wasn't suggesting at that time that it was appropriate to move to that stage. But the discussion, as I said, was around being able to compel people to turn up at a place in a certain time. And the only similar thing we had would be to detain them and take them there. And from memory, that was the route that discussion was taken.
So we've heard, in relation to the status of the officers,
Yeah.
that if they were to move from the status of witness
Yeah.
to suspect,
Yes.
that the test to be applied to that would be to whether there were reasonable grounds to suspect they'd committed criminal offences.
That's correct, yes.
As at the 14th of May, when you attended that meeting with the Lord Advocate, what was your view about the status of the officers at that time?
At that stage, they were still witnesses, as far as I was aware.
As I understand it, there were no initial accounts or statements available to PIRC at that time?
None at all, no.
But on the basis of the information PIRC had in terms of the investigation that had been carried out up until that point, did you have any grounds or any belief that they could have been suspects?
Not at that stage, no.
Can I ask you again about the phrase, this is a carbon copy of the Duggan scenario? I'm interested in your understanding about why this scenario in relation to Mr. Bio would have been viewed as a carbon copy of the Duggan scenario.
Well, although we were in the early stages of this investigation, by that time we knew that the police officers had decided not to fill in documentation that we would have expected them to fill in, use of force forms, etc., CS forms, etc. We had attempted to have them provide operational statements. That hadn't occurred either. And from discussion around the Duggan inquiry, I knew that although officers had turned up as they had to for the interview, they hadn't provided any statements. And I think, again, from discussion, I learned that the IPCC believed that that ability to commit them to attend for interview was actually worthless, because quite often the SAT refused to answer questions and then went away to think about it. And I think that the problem there is that, yes, people were becoming exercised at the fact that the officers by the 14th of May still weren't engaging with inquiry, and I fear that that may perpetuate.
At that stage, did you feel you had any power to compel the officers to attend for interview or to provide operational statements?
None whatsoever.
Did you feel you had any power to compel them to provide either brief accounts or initial accounts or brief facts?
I'm afraid not, no.
Is that something that would have assisted PIRC if
Yeah.
that power had been available?
No doubt, yes.
And then if we look at page 2 of these minutes, please, you'll see halfway down there's another reference to your initials, JM. SPF position is that they employ Peter Watson, but they disagree with legal advice. Should be for each individual officer to decide. AA has set himself up as a family liaison point. Can I ask you what your understanding of the SPF position was at that stage?
I didn't really have much contact with the Federation at that time. It was Mr. Watson that I had dealings with. I know that I had experience where the SPF take on a lawyer during investigations, and the blanket coverage appears to be say nothing. I was never necessarily of opinion that that was the best advice in all instances. And I know that in a past life that I'd certainly had discussions with members of the SPF who shared that view, that it was always, I wasn't always appropriate to say nothing at all.
So, from what you're saying, could this have been a reference to your prior knowledge of SPF positions rather than specifically in relation to this investigation?
Yes, because this was part of a larger discussion around the ability to compel. And as you know, that by then, we had actually approached officers individually. Because as I said earlier, it's all very good and well Mr. Watson holding the position that he has provided advice not to speak. I wanted to hear that from the officers. I don't want an officer sitting at home wishing to assist this inquiry and give a statement and feeling that they couldn't because of this blanket coverage.
All right, thank you. And then if we move slightly down the page, please, you'll also see a small reference where it says, LA, Lord Advocate, PM was far too quick. That's in brackets. Is that something that the Lord Advocate said? Do you see that in the second line there? LA, PM was far too quick.
It's noted there, I must have said it. As I said,
You don't remember.
There was a lengthy discussion that day.
All right, thank you very much. So, going back to return to the 5 principles, can I now move on to the, there's the aspect of the victim involvement, or the next of kin must be involved to an appropriate extent.
Yes.
That was in a reference that was in the Article 2 document we looked at the last time you were here. And can I ask you about the meeting with the family and Kate Frame, the Commissioner?
Yes. We've
heard that took place on the 3rd of September 2015.
Okay, yeah.
Could we look at paragraph 508 of your inquiry statement, please? There we are. It says, Mr. Anwar and the family wanted a meeting. We would have been open to a meeting with the family before this point, but it was never requested, and I suppose we never offered it. Although when we say we didn't meet the family, of course we met with the family. The organisation met with the family through John McSporran, Billy Little and the FLOs. The people who tend to take on these meetings are the senior investigator and the FLOs.
Yes.
So there had been meetings.
Yes.
Between the investigators or the FLO.
Yeah.
But in terms of a meeting with the Commissioner, as we understand it, the one and only meeting with the Commissioner was the 3rd of September.
That's my understanding and memory, yes.
Thank you. Can we move up slightly, back to the top of that paragraph? It says Mr. Anwar and the family wanted a meeting. We would have been open to it, but it was never requested and we never offered it. Looking back now, do you think that there may have been benefit in the Commissioner offering a meeting prior to the 3rd of September 2015?
I would have to agree. It wouldn't have done any harm.
Yeah. Can I ask you to look at the management policy log, PIRC 04154. It's page 94 of the policy log. While we wait for that to come up on the screen, because it's a long document, what I'm really interested in here is a reference in correspondence from Mr. Anwar. And it's an email that's attached behind Decision 61. Here we are.
Okay.
So it's dated the 28th of July 2015. So this is a number of months after, 2 months after, more than 2 months after the death. And could we look at page 2, please? And it's Roman numeral 5 I'm interested in.
Yep.
It says here, on a number of occasions a meeting has been requested with Kate Frame, but the family and ourselves have not had the courtesy of a response to this request following her return from leave. If it is the case that Miss Frame is unwilling to meet us in the Bio family, then please advise. I'm interested in, obviously your inquiry statement says A meeting was never requested. You would have been open to that if it had been requested. But here it seems to give the impression that there had been requests made for a meeting with Ms. Frame. Were you aware that requests had been made?
No, I wasn't. I wasn't aware.
Had you been aware that Mr. Anwar and the family were keen to meet with Ms. Frame, is that something that you could have pursued or sought to arrange?
Oh, absolutely. I would have no reason not to do that.
Right. Thank you. Now, if we could go back to your inquiry statement, please. I think at paragraph 514, there we are. I've been referred to the PIRC's family liaison log, which contains a note of PIRC's meeting with the family on the 3rd of September. I'm afraid there are some things that I just can't remember the specifics of. And I think in paragraph 505, you say you don't recall it was particularly positive, I think is the phrase you use. I still think the family weren't happy with the level of information that they were getting. I understand that as well, because families want to know. You say it wasn't particularly positive. Can you give us your impressions of that meeting and how it went?
Just that the family, as I said, they rightly want information. There can be no argument around that. But quite often, either information isn't available, or in some occasions, if it pertains to particular areas of the investigation which are sensitive and evidence, it might not be appropriate at that time. And it's very, very emotive meeting for the family. I totally understand that. And it wasn't a particularly easy meeting. There was friction, but as I say, I totally understand why.
Looking back at that meeting now, do you think there could have been a better way of handling the meeting and meeting with the family?
I'm not sure how. I think I also make comment that I'm not necessarily in favour of boardroom style meetings around a table in these set of circumstances. I think it's much, much better, less formal. But it was a big meeting. There were lots of people there, and as a result, I think indeed we had to borrow a meeting room in a building next door just to accommodate it. No, it wasn't a great meeting. It wasn't a great meeting. I'm not blaming anybody. It just wasn't a great meeting.
You say less formal.
Yeah.
Can you suggest how that could have been achieved? That reduced formality?
Maybe where the meeting was. Maybe if it had been in a less business setting. But I'm not quite sure how you would manage that. That would be a difficulty, because you're going to discuss very sensitive matters. So there has to be some control around it. No, I'm sorry, I don't really think that to involve everyone who wanted to be involved or who needed to be involved, that it could have been much less formal. But that may have assisted.
Was there much discussion in advance of making it a less formal meeting and making the family feel comfortable?
I think it was more about finding accommodation that would accommodate the size of that meeting.
Do you remember any prior discussion about how the family could be made more comfortable or more at ease?
No, I don't.
Despite the difficulties, do you think that might have been a conversation worth having?
If it had made the meeting any better or was likely to, yes, it would have.
Thank you. Can I ask you about paragraph 516, please? I've been referred to Alistair Lewis's note that the Commissioner assured family all investigators are diversity trained. I've been asked what this diversity training involved. I've had so much diversity training over the years. I've had continuous updates in diversity training, and rightly so. I do remember getting an input which did talk about unconscious bias, but it wouldn't be truthful of me to say whether that was before or after. It wasn't just investigators. It was a whole organisation having diversity training, and it was outsourced and brought in.
Yes.
I'm interested in what's said here. Were you satisfied that all investigators were diversity trained at the time of the meeting?
I knew that those who had previously been police officers throughout their career would have diversity training at different locations and to a different level. Absolutely.
And for those who weren't former police officers, were you confident that they'd been diversity trained?
Again, the majority of them came from public bodies. And yes, I was aware that those bodies also had a requirement to provide diversity training to their staff.
You say you don't remember if that training on unconscious bias was before or after?
No, I don't.
You've no recollection of that?
I think if I was going to err on the side of safety, I probably think it was after Mr. Byers' death.
Right. Can I ask you about some evidence that we heard from Colette Bell?
Yes.
She gave evidence on day 40 of the inquiry last year, February last year. And I'd just like to ask you if you have any recollection of what she's describing. She talked about a phrase where it was mentioned that PIRC had inherited bad apples. Do you remember anyone saying anything along those lines?
No, I don't, no.
And
sorry, was that at that meeting?
Yes, a meeting with the Commissioner.
No, I don't.
You don't remember. And then she recollected the Commissioner. Her impression of the Commissioner was that she was very snide and felt she was almost laughing at her, Colette Bell. And she says, I think at one point she actually did snigger, almost that my anger and my upset was funny to her. That's what she said. Do you remember anything along those lines?
No, I don't.
No. Do you remember the Commissioner almost sniggering or laughing?
No.
She said in evidence, I asked her, could Kate Frame have done anything or said anything that may have made things, I was asking about if things could have been made better.
Yes.
And she said she probably could have been a little bit more understanding. I just felt like she had a very bad attitude towards us. Very much she's right, we're wrong. Do you have any comment to make about that?
I'm sorry to hear that was how the Colette Bell or any of the family members felt.
Do you think that's an accurate view of how Kate Frame was at that meeting?
Not to my recollection, no. That would have been very unprofessional, and I think that would have stuck in my mind.
Thank you. Do you know anything of the, and you may not, do you know anything of the proposal in relation to the duty of candour regarding officers?
I think I've heard something recently that is being considered just now at government level, but 6 years retired now, I'm afraid I don't know a great deal about it.
Absolutely no problem, thank you. We may hear evidence in the future in the inquiry in relation to dealing with grieving families and arrangements in relation to the next of kin.
Yes.
And I'd like to ask you for your thoughts on whether you think any of these proposals might be of benefit.
Okay.
Consideration should be given to preventing a police force whose officers' actions are being considered in an independent investigation from commenting on the matters in issue to the media at all. So they should be prevented from commenting in the media about the matters that are being investigated.
Well, for the reasons I gave earlier, yes, I think that would be helpful.
Right. And is that something you think would be helpful to the families?
Yes, again, I mean, I don't think there can be anything worse than for the family than turning on the media or lifting up a newspaper and reading or hearing some contentious comment which grieves them.
And from the PIRC investigation perspective, would that be something that would also assist PIRC?
I think so, yes, for that, as I say, for the reasons I discussed earlier, that we don't want anyone being tainted by whatever they hear in the news or read in a newspaper and just assume that that must be right and therefore no reason for going forward and giving statements.
Thank you. What about the suggestion that any press release to be issued by PIRC should be agreed in advance with the family of the deceased? Have you any thoughts on that?
I would think that would depend what sort of release that you're talking about there. If it involved or in some way referred to the family, absolutely. If it was a general press release in relation to seeking witnesses, for example, I'm not so sure at that level that anything that might concern, upset the family, absolutely.
Do you think there would be merit in simply informing the family of press releases that were going out, even if it was as simple as witnesses to an incident?
Again, it would do no harm. It wouldn't undermine the investigation, no.
Have you any thoughts on whether that could actually assist bolster trust and confidence in the investigation, that steps are being taken?
Yes, I think it probably would.
Thank you. Do you have any thoughts on whether media briefings by police officers or on their behalf, if they are inaccurate or considered by PIRC to be inappropriate, should be commented on by PIRC, and whether they should be considered as a misconduct issue?
Oh, now, that's a different matter altogether. I suppose you'd have to look at every incident in its own merit there, and whether you would wish to respond or whether you'd wish to try and clarify a point. That is a difficult one. You know, if it was a ridiculously and obvious misleading statement, yes, there might be scope to do a bit more with it.
We've heard in the inquiry that in any event, issues of misconduct are for Police Scotland rather than anyone else.
At this moment in time, the legislation, misconduct matters only relate to senior officers when they become PIRC investigators. That's so Assistant Chief Constable and above. Below that, it's a Professional Standards Department investigation.
And nothing to do with PIRC?
Absolutely nothing to do with PIRC.
Thank you. Can I ask you about other evidence we may hear about possibly the supply of literature to a family who are grieving
Yes.
at an early stage after the incident has taken place? And it may be that a booklet is given or a pamphlet of some description can be given. Could we look at paragraph... Oh, no, sorry, that's fine. We may hear evidence that this is not always the norm in dealing with families who are grieving, although guidance documents are available. And I'm interested in, if we could look at PIRC 04457, please. Now, this is an example of a guide that's available for families on the role of the PIRC and family liaison officers.
Yes.
And so this is a guide that gives families some information in
Yes.
writing at an early stage, as I understand it, in an investigation. Now, is this something that you were involved in considering and preparing in your role, information for families?
Well, again, I think it was something that was also and always available, even when I was in the police. So yeah, it's good practice that families should be provided with information at the appropriate time.
Do you think that handing them a leaflet with things written down is a good way to communicate?
Well, it's not sufficient, if that's what you're asking.
No,
Ultimately, I would expect an explanation and a discussion about what was contained in that leaflet to make it sure that the family understood, and because I can only imagine there's so much for families to take in at that time that explanation would be required.
So would you agree that the combination of both an explanation given face-to-face perhaps, or in some way with the family, but also written leaflets might be a good combination?
Yes, because the written leaflet for me would be much of an aid memoir after the event, because again, whether the family would take everything in at an early stage would be difficult to say under the circumstances. It would also, a leaflet that maybe give them the opportunity of, oh, I should have asked that, and to go back with those type of questions.
And would you agree or disagree that giving the family information such as they may wish to appoint a solicitor or take legal advice, do you think that would be useful information for the family?
Yes, I think it probably would, yes.
And is that something that PIRC are willing to work with a legal representative in dealing with the family?
Yes, well, we were willing during my time. I don't necessarily, again, think that it's always the best way, because I think there's a difficulty there in building any sort of understanding or rapport between the investigators and the family. I think you may on occasions miss that opportunity.
Who do you think is best placed to build the relationship and the rapport with the family?
Well, I mean, if we're talking about a set of circumstances, and I think I've said this before, if the family wish a solicitor and that's the way that they want to do it, that's absolutely correct as far as I'm concerned, because it's down to the family what best suits them. And there's absolutely no doubts that the family will build a rapport with that solicitor. But I also think that it would be beneficial for Flows to build a rapport, to get an understanding, a deeper understanding of the family's needs. I'm not suggesting that you would need to, or it would be even correct, to try and exclude a solicitor in these circumstances.
Would you like to see, even if there is a solicitor appointed, for the Flow to continue in their role, building that relationship with the family?
Yes.
Would that give PIRC the most assistance and the least hindrance in terms of investigation?
I think it would, yes.
Thank you. Now, this may be something you're not able to comment on, but do you have any views about whether literature such as this should advise families about financial matters, perhaps funding issues, whether there should be funding issues, whether that would assist PIRC in building a relationship with the family and allow the family to instruct a solicitor if they wish?
Well, again, from experience, I don't think that sort of information would be harmful. Again, it would open up another avenue to support the family. So I don't think it would be harmful.
Can I ask you some questions about race? We've heard that Mr. Bayo himself was black.
Yes.
And I think if we go back to your inquiry statement, please. If we could look at paragraph 421, 420 to 422 really I'm interested in. And here, if we start with 420, you were asked prior to the 3rd of May 2015 what experience you had of investigations of deaths in custody or deaths following police contact in which race was a factor to investigate, and you don't recall one. Does that remain the position today?
Within PIRC, yes.
Within PIRC.
Yes.
And 421, I've been asked if PIRC had ever considered the issue of race within an investigation prior to 3rd of May, or if race became a consideration in an investigation subsequent to the investigation. Not that I recall, no.
Not that I recall, no.
Is that correct?
Yes.
And then 422, I've been asked if I considered the investigation of issues of race to be more challenging for PIRC if this was the first time that PIRC had been required to investigate allegations of racism or issues of race. And your answer is no, because it's all about gathering evidence and finding where the evidence leads you. What you're trying to do is start off by gathering all information that may be available. Take statements, see what you can glean from those statements, and see if you find information or evidence that tends to support that race or racism played a part in events.
Yes.
So, looking wider at the team who were under you, were you satisfied that they had experience of investigating deaths in custody or after police contact where race was a factor?
Well, clearly not within their time in the PIRC, because I wasn't aware of any such investigation, no.
Were you satisfied that they had that type of experience from previous work, say, with Police Scotland? Or?
I certainly was of the opinion that they had the considerable investigative experience, sufficient, I would suggest, to identify whether or not race was a factor.
And did you have any concerns at that stage that, although you've talked here about gathering evidence and finding where the evidence leads you, did you have any concerns about their ability to identify what may be relevant evidence to race?
My expectation would be when they're conducting an investigation that they gather all of that information that's available and given to them and is obvious, whether that be in form of a statement, which would be the normal process, and to submit that to the inquiry, and that these statements are going to be considered at length by the senior investigator and his or her deputy.
What if it's not obvious?
If it's not obvious, it's going to be difficult in any case.
And so in terms of, you mentioned statements, would you expect the lead investigator, the senior investigator, to be scrutinising those statements, looking for any adminicle of evidence that may indicate race was a factor?
Yes.
We've heard evidence that from the 3rd of May 2015 to towards the end of August, maybe into the 2nd of September 2015, that PIRC were taking cognizance of race.
Yeah.
If issues emerged.
Yes.
But Mr. Little's explained he didn't view that as an active line of investigation. It was taking cognizance, being mindful, or keeping an open mind. Look, if things emerged, they would take that forward, but not an active, proactive step by PIRC. Would you agree with that?
That would probably be right, yes.
But then from end of August, 2nd of September in particular, at that point the Crown Office issued a letter of instruction specifically referring to race, and from that moment it was absolutely part of the terms of reference.
It was part of the terms of reference, but I would suggest that even before that letter was issued, that part of the investigation relating to the officers concerned, the central officers to this, would be to gather their personnel records, their discipline records, their complaint records. So ultimately, if there had been anything in these records that suggested a racist or racial element, that would have been gathered at that time during the investigation. I don't think that the letter on the 2nd of September necessarily, I think it put it on an official footing from Crown, if we put it that way. It became part of the terms of reference rather than the general investigation.
Can we look at that letter, if we have it available, 2nd of September? Sorry, I don't have the reference at this precise moment. If I may, I'll come back to that after the break. Thank you. Could we look at paragraph 160 of your inquiry statement, please? And it says here, I've been asked if I recall Mr. Bio's race playing a part in the development of these hypotheses. We've heard evidence about hypotheses. Not immediately, I don't, because it is still early on. I'm not discounting that, but this is the police responding to a live incident. Unless there's evidence to suggest that there was some racial or racist motivation to it early doors, yes, you'd be open to it, because when you're conducting house-to-house inquiries, you're not just interested in what people see, you're interested in what they hear. If house-to-house inquiries or any other witness statement suggested that there had been inappropriate remarks which would have been of a racial matter, clearly at that stage you would have considered that in more depth. I honestly don't think it was at the start. I think later on it was considered.
Yes.
Were you essentially looking for obvious, overt comments in relation to race?
At the very early stages of the inquiry, yes, everyone had to be aware that if those overt comments were made or heard, or there was any evidence that suggests that should be highlighted.
And then at 161, you say, I've been asked if I consider that the impact that Mr. Bio's race had on events should have been a hypothesis from the outset of the investigation rather than later on. I think you need to follow the evidence, and I think at that early stage there was no evidence. We didn't even know at that stage why Mr. Bio had died. We had no idea of the cause of death, so maybe it would have been better if it had formed one of the hypotheses early on, and it would have done no harm to have considered it.
Yes, I would agree with that.
And this is your statement. So
yes, that's my statement. Yes.
We've heard from Leslie Bowl, who is a police officer, that she was very early thinking that whether Mr. Bio had been treated differently because he was black.
Yeah.
And she would have seen that as a hypothesis about a possible line of investigation if the police had been continuing with the investigation. You seem to suggest here that it should have been a hypothesis from the outset rather than later. Do you agree it was not one of the hypotheses at the
yes,
outset?
I think that is correct, yes.
Right. You've said it would have done no harm to have considered it. Do you have any thoughts on whether by not considering it at an early stage, harm was being done?
I don't think so. I mean, it's a difficult set of circumstances that you're putting to me here. Clearly, we know that Mr. Bio is a black man. But we still need to have evidence to support whether or not that played a part in the way that the police dealt with him. And at those early stages, there was no overt evidence. However, I do appreciate the point around that it would probably have been better in hindsight had that formed part of the hypothesis from day one.
Because we've heard that one of the hypotheses from the very beginning was perhaps that he died of natural causes. And there was no evidence as such to suggest he had died of natural causes, but that was a hypothesis that was being investigated or could have been considered at the start of any investigation.
Well, until a post-mortem, the result is knowing. That's a possibility, but I don't know whether I would actually consider that at that stage as being a hypothesis. I think I would want to know what the evidence of the post-mortem was first.
So can I maybe just be clear, what is your understanding of a hypothesis? Because it may be that other evidence we've heard people have different views.
It's just purely and simply that you start off with a blank piece of paper that you consider what may or may not be pertinent to the investigation. And as you work your way through, evidence will either build on that hypothesis and it will continue to be a line of inquiry, or alternatively, evidence will rule that hypothesis out.
All right, thank you very much. I've very kindly been given the reference to the 2nd of September letter. Could we maybe look at that? COPFS 02557. And this is the letter dated 2nd of September from Crown Office to the Commissioner. And you'll see that on the screen.
Yes.
And you'll see that, I should say, we've heard evidence that in the August of 2015, the interim report had been sent to the Crown. And this letter was sent to Cape Frame after that interim report had been prepared.
Okay.
And the letter you see on the screen is a lengthy letter. It spills into 5 pages, and it's from Les Brown, Head of Criminal Allegations against the Police Division, Cat D. So if we look at page 1, if we can move down that page towards the bottom of the first paragraph, it says PIRC would be instructed, if we could just move the just go to the first paragraph, please, lovely. PIRC would be instructed to carry out investigations in respect of a number of matters in order that a properly informed decision can be taken by the Crown as to the most appropriate way to proceed. And then there are numerous bullet points, and if I had to tell you, there's 13 bullet points as part of this letter. And you'll see that they start with a request for a detailed analysis to be provided. And there's reference at the bottom of the first page to independent experts. There's quite a large number of references to independent experts. And if we could start by looking at page 4, which is the top of page 4 is the 12th bullet point. I require confirmation from the Commissioner that issues of race and whether there is any evidence of racial motivation is a primary focus in the PIRC investigation. The investigation should examine whether there is any evidence that any of the officers involved has expressed any racist views or opinions in the past, in particular indicated that officers from within the Fife area had been investigated for texting racial slogans and that any of their officers was referred to him. We've heard evidence about a number of letters of instruction, and this was the first that specifically mentioned race.
Yes.
And so there's a direction and instruction here to PIRC in relation to race, and for PIRC to examine whether there's any evidence that any of the officers involved has expressed any racist views or opinions in the past.
Yes.
And if we can also look at another letter. Prior to this letter, there was, I won't put it on the screen at the moment, there had been a letter from the end of July from Mr. Anwar raising the issue of race with PIRC. It wasn't part of any terms of reference or letter of instruction, but he'd written directly to the Commissioner.
Yes.
And he had raised issues about race. So that was from the 28th of July. Prior to that, there weren't any letters to the Commissioner from Crown Office which referred to race at all. So when you said a moment ago earlier, a few minutes ago, that the matter was already being handled, it could have possibly been raised from the 28th of July letter sent by Mr. Anwar, which found its way into the management policy log in terms of handwriting from Mr. McSporran.
Right.
But we've heard evidence from Mr. McSporran and Mr. Little that there was no active line of investigation regarding race in that period up to effectively this period round about the end of July, beginning of to the 2nd of September.
If that's their position, that must have been correct.
Right, all right, thank you. I'd like to move on to the 4th of June, which is when the officers gave statements.
Yes.
And we've heard evidence from Mr. Little and Mr. McSporran in relation to what was known as a witness interview strategy.
Yes.
There are, and it was agreed by them that there were no questions on that 13-page document which specifically focused on the issue of race. So there were no questions written down in that witness interview strategy if the officers had acted in a certain way because Mr. Bio was black, or if they would have acted a different way if he'd been white. Yep. And at that stage, there was this entry in the decision, a decision in the management policy log to take cognizance of issues. But we've also heard evidence about the content of the statements that were given to PIRC voluntarily by the officers after that date. And one of the matters that we've spoken about is language that was used in the witness statements. And I don't know if you've seen any of that evidence or heard any of those matters.
Well, I have, because, and I think it's parts of it are covered in my statement, so it was brought up during my interview, yes.
So we've heard that certain officers had used the word coloured.
Yes.
Kaylee Good had made an apparent connection or link between the fact Mr. Bio was black with a terrorist, with this being a potential terrorist incident. There were a number of references to Lee Rigby, which had been a recognised terrorist incident.
Yes.
And a reference in one of the officers' statements to a phrase, a wee Pakistani doctor.
Yes.
And I'm interested in whether you were involved in any way in analysing those statements or considering the language used in those statements from the perspective of considering whether issues regarding race were emerging.
No, I wasn't involved in analysis of those statements.
And who would you have expected to be doing that type of work?
The senior investigator.
Right. As far as you know, at any stage, was any consideration given by PIRC to whether any inferences could be drawn from the use of certain language that may be considered potentially to have racist connotations?
When we speak specifically about the language that's used in the statement, and particularly the word coloured, that's offensive as far as I'm concerned. It's certainly not language that I would use. It would certainly flag up if it was a member of my staff that at the very, very least there was a training requirement. And had it been a member of my staff using that type of language, I would have addressed it at that time. So it's not appropriate language.
And when you say a member of your staff, if you, obviously you have had considerable experience as an officer, if you had been sitting in an interview with an officer who used that type of language, what would your reaction have been?
Just as I say, I wouldn't have been impressed because it's not the type of language that should have been used. I might even have made that comment. I might even have, if I had been conducting an interview, I might have actually made that comment inappropriate.
Would you have considered that an appropriate point to which maybe to ask further, more probing questions about race or why that language was being used?
Yes, I think that there probably should have been more probing questions made in relation to not just that area, but other matters that were discussed during those statements.
What other matters?
Well, just generally allowing clarity. Some time ago, and I don't actually remember all of the aspects of the statements, but an interview advisor pulls together an interview plan. That doesn't mean that that is the only questions that you ask. You're not running through a script. You would expect experienced officers and experienced investigators, to use their common sense. And if there was a lack of clarity, or if there's something that needed expanded upon, you'd expect that to occur.
We've looked at the witness interview strategy in detail.
Yes.
With some of the previous witnesses, and noted that we've heard evidence that it is legal for police officers to use force in their operational duties, but in order for that to be legitimate, it has to be justified.
Yes.
And in order to justify it, each individual officer must explain why it was reasonable, necessary and proportionate.
Absolutely, yes.
They have to have looked at other less forceful options and excluded them, either in advance or having tried them and failed.
Yes.
And they have to use the absolute minimum level of force that is required to achieve their goal.
I understand that, yes.
And we've heard that that was a key issue in relation to the incident regarding Mr. Bio.
Definitely.
And we've also heard that in the witness interview strategy, there was no questions I should say before we move on, that each officer has to justify each individual use of force.
Yes, I'd agree with that.
So if there are 3 baton strikes, each baton strike has to be justified.
Absolutely.
And we've heard evidence that there were no questions in the witness interview strategy regarding why did you use your baton? Why did you use that level of force? Why did you not use a different technique or a different tactic?
Yes.
That type of thing.
Yes.
Does that concern you that there were no questions in the witness interview strategy about use of force?
Yes.
Why does that concern you?
For the reasons that you have just given, that you'd expect an explanation, you'd expect a justification around that, and if you don't ask that question, either at that interview or indeed if having then considered and analysed the statements, it would probably have been appropriate to go back at that stage and make sure those questions were asked.
So even if they hadn't been asked by experienced investigators or otherwise, for whatever reason, you think there would be merit going back and clarifying that?
Well, it's disappointed that it's not asked in the first place, but there would have been merit in going back and clarifying, yes.
Thank you. Thank you very much. And in relation to potentially racial stereotypical language, maybe portraying Mr. Bio as massive or the biggest male that I've ever seen.
Yeah, I think I've made comment on that, and again, in comparison to at least 2 of the police officers, I don't think you could describe them that way.
On the face of it, of that comment, there is nothing obvious about race. No words.
No.
That are automatically offensive.
No.
For that reason. But do you think that comment in itself should also have been a red flag to investigators in relation to the issue of race?
If we're talking about it being stereotypical, which I agree that it probably is, because it's used when you listen to media, when you listen to read newspapers, etc. Yes, that should probably have been delved into more deeply.
And how confident are you that your investigators were adequately equipped to identify a comment like that as potentially a racial stereotype? Again,
They're experienced. There's lots and lots of experience there. I think it would have been be unreasonable for them to understand that may very well be a stereotypical quote.
Are you confident that they were in a position to understand that?
That's a difficult one for me to answer, isn't it? I would have hoped they would have been.
Right.
But if they haven't asked it, I would then have my doubts in some ways.
Thank you. Could you give me a moment, please? I wonder if that might be an appropriate time to...
We'll take a 20-minute break now. Ms. Graham.
Thank you. Before the break, we were talking about the language used in the officer's statements.
Yes.
And we heard evidence from Kate Frame in relation to this matter.
Okay.
And that I think ultimately, and it'll be a matter for the chair, that she noticed that analysis about the language did not feature in the PIRC report. And that ultimately, as I understand her evidence, she accepted that considerations around the officers' language in their statements should have been flagged within the PIRC report. But she explained that she'd raised this issue with you and that you had taken the view that they were misconduct matters for Police Scotland, and the report should simply just be sent to Crown Office. Do you remember any conversation with Kate Frame specifically about the use of language in officers' statements?
There was a lot of discussion about the style of the report more than the content, I would suggest. There may very well have been discussion about the language used. What I don't recall is having an opinion or otherwise whether there should be a particular paragraph or section within the report that covered it or not. I do not recall that.
Do you remember suggesting to Ms. Frame that this was a matter for Police Scotland because it was an issue for misconduct rather than an issue that should be contained in the PIRC report?
But even if it was a matter for Police Scotland, I don't see why that would preclude it from appearing in the PIRC report. No, I don't understand that one.
Do you have any recollection at all about...
I said there was so much discussion more around style than content from my memory. I do recall the type of language that was used because, you know, it does stick in your mind that it's not appropriate. I don't specifically remember that being a standalone discussion about where that should go in the report or whether it should not go in the report. If it was a matter of evidence that had been gained during the investigation, I don't think I would have had a strong opinion that it shouldn't have been recorded in the report.
And looking back now, in fact, do you think that should have been in the PIRC report, the use of language by officers?
Well, at the end of the day, the statements were going to be supplied and it was covered in the statements, so I don't see why it shouldn't have been in the report. It would have been good practice, I think, to put that in the report.
Right. Thank you. Could we look at your inquiry statement again, please, paragraph 431? You say you're continuing in your statement in relation to the issue of race. I think if the evidence was there, we would have found it. I don't know how much broader you can make the investigation. For example, I do not know how you investigate unconscious bias for the very fact it's unconscious. I think you'd have to look at what training people had, what their understanding was of that training they had, negative stereotyping, all of that. But that is a very difficult thing to prove or disprove, I would suggest. Yeah. I'm interested in what you say here about not knowing how you would investigate unconscious bias.
Well, I think I was being honest about that. I mean, what you would be looking for first and foremost was overt evidence in relation to race, to support whether or not that race was a key factor in the investigation. The unconscious bias element of it, as I say, is very, very much derived from stereotyping, whether that be positive or negative stereotyping. And to this day, and that's maybe a fault on my behalf or something that I lack, but I'm not quite sure, other than to have considered all of the evidence, including the officers' personnel files, their discipline records. That language, in fairness, that was included in statements, how you would identify unconscious bias in an individual.
Had you had training in relation to conducting an investigation where there was perhaps a suggestion of unconscious bias?
No, I hadn't. No.
Had any of your investigators had that training
Not to my knowledge.
prior to Mr. Bio's death?
Not to my knowledge.
We heard evidence from Ms. Frame, as I've said, and we asked her questions about training. And she gave evidence that the responsibility for identifying gaps in the investigator's training was your responsibility. And she said that you did not raise with her the fact that further training would be required for investigators in relation to investigations where race was a factor. And she also said, in response to a question about whether she'd considered putting training in place for this type of investigation, that professional development of that lay within the investigation team. Do you have any, can you confirm, was it your responsibility to raise issues about training gaps?
Yes, I would imagine it would have been, yes, in my role, yes.
Had you identified a training gap in relation to investigations where race was a factor?
No, I hadn't, because we hadn't encountered one at the stage when Mr. Bio died. And although the organisation by that time was 2 years old, I have to go back to the point that the number of investigations from the beginning of April 2013 to 2015 had been steady. And that, yes, we were dealing with the training in relation to scene management, to flow, to the understanding of death in custody, to fatal accident inquiries, and working that in with the other demands. If that's a failing on my behalf, I need to accept that.
Do you think that is a failing on your part, looking back at things now?
Well, I suppose it's a matter of, did I give it consideration, and should I have given it consideration? I suppose until this set of scenario rises, and not having had this, as I said earlier, is the only death that I was aware of that race was a consideration. So it would have been training that, it's important training, I'm not saying it's not important training, but would it have been any more important at that time than understanding that people were aware of their roles as flows or scene managers or the likes? But as I say, I accept that if there was a failure in that area, that would therefore have to lie on my shoulders.
Can I ask you about considering a comparator? Can we look at paragraph 433, please? This is your inquiry statement. I've been asked if, when investigating issues of race, PIRC considered attempting to identify comparator evidence that might have permitted PIRC to compare how Mr. Bio was treated against how other individuals who were not black were treated in similar circumstances. I don't believe so. I'm not quite sure how you could do that. I feel that it would have been necessary to identify incidents which were identical in all aspects of the events leading to and including the interaction between the police and Mr. Bio to draw a meaningful comparison. So you've been asked here about the possibility of identifying a comparator to Mr. Bio in relation to the circumstances that he found himself in, but a white comparator. And you say, I don't believe so. So was there no consideration given at all by the PIRC investigators to that possibility?
Again, I don't think there was, and I think at the end of the day, lines of inquiry that are taking on are lines of inquiry that you actually believe that you can see an end to. And to repeat what I said in that summary of evidence, for it to be a scientific comparison, I would have to suggest that every aspect of it, regardless of the individual colour, would have to be almost exactly the same to make a meaningful comparison.
So in your view, was that a sort of impossible goal to achieve a precise comparator?
Yes, I believe that is the case, and I think that's maybe why it didn't enter my mind.
And so you simply did not even consider whether that could be done?
No, I didn't. No.
Can I ask you about something else Ms Frame said to us in evidence, that in relation to questions about comparator evidence, comparing how Mr Bio may have been treated against someone who was white. She said that was a consideration as part of the investigation, and she said that she discussed it with a number of investigators. She named you at the beginning of the investigation, she said, and there was an indication that they would take cognizance of this.
I don't recall that, for the reasons I've just given.
So do you remember any discussion with Ms Frame that was in connection to a comparator, or the difficulties you believed might be experienced by investigators in finding a comparator?
I don't recall that discussion. I really don't. But if the discussion had taken place, the viewpoint I've just given now would have been my viewpoint then, but I do not recall that discussion.
Thank you. Can we look at paragraph 438, please, and the following paragraphs we'll go through. I think, if I may, I'll simply summarise what you say here. If we start with 438, I've been asked if PIRC had any guidance or reference materials in relation to investigations touching on issues of race. There wasn't a particular standard operating procedure or memo of understanding or anything like that in relation to dealing with matters that related to race. Now, we've heard that now there is guidance for PIRC investigators doing investigations where race is a factor, but there was nothing like that available to your investigators. Then you say at 439, you never sought guidance in relation to previous investigations or inquiries, such as the Lawrence inquiry. So didn't your investigators never consider whether there was guidance available out there or documents that could assist?
I don't know whether John McSporran did.
Right. But there was nothing done by you about seeking out guidance elsewhere. You say that you never discussed the Lawrence inquiry at 440?
Not that I recall, not during the investigation, no.
And at 441 you say you never sought guidance from any third parties?
No.
In relation to assistance they could provide in relation to an investigation?
I think in relation to the approach to the IPCC, where I totally understand that they were probably more experienced than that, I don't honestly recall much coverage of that type of investigation by PCC featuring in positive feedback.
Right. We've heard that there was some guidance in September 2015, but not at the time in May 2015.
Okay. Right.
Were you aware that there was any attempts going on down south to prepare guidance to assist investigators?
No, I wasn't.
And then at 442 you say, I've been asked if I consider this could have assisted PIRC's investigation and permitted PIRC to learn from other experience, and you say it may have.
May have.
Yeah. So if you were thinking now about an investigation where race was a factor, and I appreciate you've retired, do you think these sources may have been of benefit to your investigators at the time?
As I said, I'm not so sure about the IPCC aspect of it. A number of the investigators would be more than aware of the Lawrence inquiry because it was well covered in policing circles in the years since the Lawrence inquiry. I'm not 100% sure just how much similarity in the investigations there were. However, I am prepared and should accept that there may very well have been matters therein that could have been of assistance.
Thank you. So, looking back with hindsight, do you think there may have been some merit in looking for these sources if they existed?
I don't think I could argue with that, yes.
Can we look at 465, please? And you were asked if PIRC was sufficiently equipped to investigate issues of race relating to deaths in police custody or deaths following police contact in 2015. And you say, I thought we were, yes, but maybe there was an opportunity to seek guidance from people who had more experience. Maybe I should have considered whether there was an outside agency that could have assisted. Maybe that was a fault on my part. I don't know who I would have turned to. There are other investigative bodies that probably have faced that, and in hindsight, it may have been worth turning to them. And what investigative bodies were you thinking of there?
Well, it would have to be the likes of IPCC, it would have to have been the Garda Síochána Ombudsman or the PSNI Ombudsman, a body like that. I think, from my experience, the only type of other organisation that you might have turned to would have been a police agency elsewhere, and I'm not quite sure whether that would have been appropriate when we consider independence.
All right, thank you. Can we look at 661 now, please? And I think in this paragraph you were asked about what additional training PIRC investigators may have benefited from at the time. So 661. There we are. And you say the obvious one with hindsight would be a better understanding around race and what part race could have played in that investigation. But other than that, we had a breadth of experience across most, if not all, investigative disciplines. Now, when we spoke to Ms. Frame about this, she said that there were practical limitations in relation to resourcing, both in terms of financial implications, but also releasing investigators from their day-to-day duties to attend training. Can you tell us a little more about that?
Well, that is exactly the set of circumstances, and it goes back to the discussion around setting the organisation up, where there was a very, very difficult role to try and identify what the demand profile would be. And very, very quickly, we realised that the numbers that we were given were probably smaller than should have been, that we get far more investigations, for example, from the Crown than had ever been expected. And yes, it's great to be able to train people constantly, and in areas that we could, we did. But the demand profile took over very, very quickly, and it was very, very difficult to release staff numbers and to take on different training.
Thank you. As part of the investigation, were you aware of any consideration being given to whether inferences could be drawn from evidence that was available regarding the way that family and friends of Mr. Bio had been treated in the immediate aftermath of his death? And I'm thinking specifically about searches of houses, recovery of DNA, recovery of clothing from Martin Dick, Kirsty MacLeod, Mrs. Ahmed and Mr. Rashid, who were relatives of Mr. Zaid.
I'm not quite sure what the purpose of that was, and again, that was Police Scotland that conducted that area of investigation. And it happened before we became involved in so much as it happened before the terms of reference were changed. So as far as drawing an inference around that, I'm not quite sure what inference I could draw.
So is it fair to say that no consideration was given to whether an inference could be drawn in relation to whether this was an indication of racist or racial discrimination?
No.
In paragraph 645 of your inquiry statement, you say, in no way, shape or form did Mr. Bio's race negatively impact. You see it there? In no way, shape or form did his race negatively impact on my decision making. Every line of investigation was pursued as far as I'm aware. On reflection, regarding the questions I've been asking you about race and the information I've given you about other evidence, do you wish to reflect on that statement? Every line of investigation was pursued as far as I'm aware.
That is probably an overstatement, I would suggest, having discussed what we have discussed today.
Thank you. The other aspect of the investigation I'm interested in, this is after the terms of reference has been extended, and I understand that there was an active line of investigation pursued regarding statistics.
Yes.
And recovery of data to look at whether there was an issue in what was then the area of Fife particularly. And we have heard that there were some issues about the analysis and the ability to analyse that. And I think Ms. Frame gave evidence that race itself could not be extracted from the data to look at that in isolation. In terms of the investigation and the investigators, how satisfied were you that they were equipped to deal with statistical analysis?
Well, again, that was down to the senior investigator. Right. If he felt that he or others within the group weren't capable of that, that's exactly the type of thing I would have expected them to come to me about.
Did he ever come to you about that?
No, because ultimately that would have been about buying in a resource to do that. And that was absolutely the type of oversight role I had at this time. It was not, and it was totally impractical for me to sit as a director of investigation, determine every line of inquiry and every investigation that was ongoing. Hence the reason you appoint a senior investigator to take that responsibility. And if that senior investigator during the investigation hits hurdles or challenges around something like an analysis of statistics, then my expectation would be that I would be approached to see whether we could remedy that.
Were you ever approached?
No, not around that.
Okay. Could we look at 598, please? We've heard evidence in relation to intelligence that was held by Police Scotland in relation to Mr. Anwar and the badging of that intelligence as refract. I do recall a discussion around that. The headings used within the intelligence system, and I believe that it referred to counter-terrorist related matters. I think it was held incorrectly under that heading. Mr. Anwar's business was totally legitimate. I wasn't involved really in any discussions around that. That again was down to the senior investigator and his team. Yes. And I'm not wanting to go into the background of that. We've already got evidence available. But what I am interested in is whether it was ever considered as part of the investigation, whether inferences could be drawn in relation to race from the information you had about intelligence.
Well, again, that would form part and did form part of the overall report. I think the bigger problem there was not getting to see what that intelligence was. And I think you would have had to have seen what that intelligence was before you could have made that determination. And as far as I recall, the PIRC investigation never got to that extent.
Thank you. Can I ask you about lessons learned? I think you were asked about this in paragraph
Yeah.
161 of your inquiry statement. The second inquiry statement, 421. Sorry, that's the wrong number. But can we go to paragraph 161? I'll just... I think that's the wrong inquiry statement. Could we look at SBPI 00421, please? We've got 423 on the screen. This is Mr. Little's. I don't need to actually look at this.
Okay.
I'll leave this to one side at the
Okay.
moment. But what we have is we've heard evidence in relation to, I've asked most of the witnesses questions about whether there was a lessons learned exercise.
Yeah.
Some have called it a debrief.
Yeah.
And I've asked Mr. Little and Mr. McSporran. Mr. Lewis has been asked whether there was some sort of official debrief or lessons learned exercise. Ms. Frame, when she was giving evidence, said that you had felt that a lessons learned exercise should not be held by PIRC whilst proceedings were still being considered. And now, I just wondered if you had a recollection of that.
I would certainly have had an opinion that a lessons learned exercise was more relevant at the end of the investigation. That doesn't, however, mean that during the investigation, if you're clearly making or identifying learning points, that you wouldn't share those. The whole matter around not doing that until such times as the determination by Crown, I take it we mean there, is made, that doesn't make sense to me. I mean, that decision wasn't made until well after I retired.
Right.
I think it would be more likely that the ability to, again, set time aside to sit down and debrief this in its entirety would have been counterproductive to other ongoing investigations, for example, the M9 investigation and other investigations that were ongoing at that time. So I think it was one of practicality. But if you identify learning points throughout, you capture those and you make sure that you spread them.
And was that something that was done during your time?
Yes, it was, yes.
So were they essentially abbreviated debriefs or mini debriefs in
I
relation
think
to
it was
learning
more,
points?
sorry. I think it was more about identifying an issue and discussing it at the time. It would have been absolutely wonderful if we'd had the time and the capacity to stop at the end of every investigation and have a complete debrief. I just don't think that time-wise and resource-wise that was. I don't think we could have managed that.
So you didn't have the capacity?
No, we didn't
to
have the
do that.
capacity. No.
Thank you. We've talked a lot about Article 2. I'd like to ask you about Article 14. So Article 14 requires that all of the rights and freedoms set out in the Human Rights Act must be protected and applied without discrimination.
Okay.
And can I ask, were you and your investigators aware of Article 14?
I don't have a great knowledge of Article 14. No.
What about your investigators in 2015?
If I didn't, I doubt that they would.
Were you aware that there were obligations, say, so states have a general obligation under Article 2, and we've looked at that in
Yep.
some detail, to conduct an effective investigation in cases where there's been a deprivation of life,
Yes.
and that obligation to carry out that investigation must be discharged without discrimination, and that's the Article 14 part. So where there's a suspicion that racial attitudes induced a violent act, it is particularly important that the official investigation is pursued with vigour and impartiality, having regard to the need to reassert continuously society's condemnation of racism and ethnic hatred, and to maintain the confidence of minorities in the ability of the authorities to protect them from the threat of racist violence. Was that something you were aware of in 2015?
No, it wasn't. No.
And then, and again, this will be a matter for submission, but when investigating violent incidents and in particular deaths at the hands of state agents, authorities have the additional duty to take all reasonable steps to unmask any racist motive and to establish whether or not ethnic hatred or prejudice may have played a role in the events. Failing to do so would be to turn a blind eye to those acts. Were you aware of all of that?
So even whether no. But having said that, I think the investigation, now whether that was actually then stepped up post 2nd of September, when Crown made it an addition to the terms of reference, I think the investigation attempted to do that.
Right. As you say, we've heard evidence that the interim report was sent to Crown Office.
Yes.
In August 2015, and that covered the period up to around about 7th of August 2015, and that document essentially presented to the Crown, as we understand, the evidence that had been gathered
Yes.
by PIRC at that time. It was 351 pages of a
Yes.
PDF. That's what we have. And although there are multiple references to black male, black guy, black coloured, and a number of references to increased terrorist risk, the threat level in the UK, there's no mention at all in the interim report about race, racism, racist, racial discrimination. There's just simply no references to those words. And no part of the report covered race or discrimination of any kind, not even to raise it and exclude it.
Okay.
Looking back now, in light of what you knew about Article 2 and what you maybe weren't aware of in relation to Article 14, do you consider that the obligations we've been talking about today were met in relation to your interim report?
Well, I think, as you say, that report did contain mention within the summary of evidence, the body of evidence. And I think that probably goes back to the discussion that we had before the break there, that information should probably have been drawn out of the body of the summary of evidence and be given its own place in a particular section of the report. That would have made it better.
Thank you. Can I move on and ask you about a briefing note? It's something that you are unlikely to have seen before, but I'd like to ask you about some of the content which you should be able to help us with. It's COPFS 02126 SA. Now you'll see that this is dated the 28th February 2020.
Yes.
And it's from Alistair MacLeod, Senior Procurator Fiscal Depute, in the criminal allegations against the Police Division, Cap D. And it's to a Justin Farrell, Head of Criminal Allegations against the Police Division, Cap D, copied to Fiona Carnan. And it's in connection with the death of Sheku Bayo Kirkcaldy on the 3rd of May 2015. And it's described as a briefing note. You see that?
Yes, I do, yes, sorry.
Now, this is a document prepared by a fiscal for the head of the Cap D department.
Yeah.
So I don't imagine you've seen this before.
No, I haven't, no.
No. And I'd like to ask you some questions about comments that are made here about
Okay.
PIRC and about the investigation. And if we could perhaps start on page 5, that would be helpful. And page 5 starts, the work carried out by the there we are.
Yes.
And I'm interested in asking about this section on statements
Okay.
that is mentioned. And it says, PIRC submitted almost 400 witness statements to the Crown which were reviewed by the precognosers. And for those listening, the precognosers will be a reference to staff in Crown Office,
Yes,
rather than anyone
absolutely,
within
yes.
PIRC. And they prepared a very detailed summary of each witness statement. I'm interested in the next paragraph. All the statements obtained from the material officers were also examined and compared to transcripts of airwave messages. Do you see that?
Yes, I do.
So this is work being carried out in Crown Office. This was to establish if there had been any deliberate attempt to mislead PIRC investigators about what they knew about the incident at a certain time. For example, whilst en route to Hayfield Road, perhaps with a view to justifying the level of force later used. An example where an officer might have appeared to be misleading PIRC was found within PC Walker's statement. In his statement, PC Walker said he was made aware by an airwave message that the weapon had been described as a sword and the male appeared to be under the influence of a substance and attacking passing cars. The precognosers' examinations of the airwave transcripts showed no such information was passed to officers en route to Hayfield Road. The content of officers' statements was addressed in the report to Crown Counsel. And then the next paragraph goes on to say, PIRC had not compared the material officers' statements, we've been calling them attending officers, the officers who attended
Yes,
Hayfield
yes.
Road, with the airwave transcripts. And it was one of the necessary steps taken by the team to establish whether or not any of the material officers had attempted to pervert the course of justice. Do you agree that PIRC had not compared the officers' statements with the airwave transcripts as part of the investigation?
I have to agree with that statement there.
Do you agree it was one of the necessary steps that should have been taken?
It's a line of inquiry which should have been considered and undertaken.
So do you agree that that was a failing on the part of the investigation?
Yes.
Can we look at the accuracy of statements, please? Now, this relates to a separate matter. During the precognition process, that's the process that the Crown staff are following.
Yes.
An issue was identified in relation to the accuracy of the statements submitted by PIRC. This came to light during the precognition of Ashley Wise. So that's when the Crown are speaking to Ashley Wise.
Yes.
At page 60 of volume 1 of the PIRC report, Wise was attributed as saying the deceased was lying on his back and that it looked like one of the police officers was using a baton on the deceased's upper chest towards his throat to hold him down. Wise provided PIRC with two statements, neither of which contained the above information. Inquiries with PIRC confirmed that the original version and the Clue 2 version both contained the reference, but the paragraph had been omitted in error when the statement had been copied as it fell between two pages. Do you have a recollection?
I do remember this.
Yeah.
I do remember this.
And so you agree that the Wise statement did not contain that part of...
That's correct, yes.
Then on 24th of October 2016, PIRC were asked to provide an assurance that all statements submitted to the Crown had been checked for accuracy and that there were no similar omissions. On 26th of October 2016, Mr McSporran at PIRC confirmed all statements had been checked and were in order. And then it goes on to say, at the beginning of March 2017, there was further concern PIRC had not proofread statements despite Mr McSporran's earlier assurances. This followed comparison of Wise's manuscript statement and typed statement, which revealed a number of typos and inaccuracies between the two. Were you aware of this situation in your role?
I remember the first set of circumstances. I remember that I think it came from Crown in a letter to Kate Frame, and she asked for me and John McSporran to have a look at what had gone wrong. And it was absolutely down to poor proofreading. Now, the discussion I had around that was that the statement should again be compared, the type statements against the manuscript statements, and where possible, by the officer or investigator, sorry, who had taken those statements. And if that wasn't possible because of sickness or ill health or holidays, etc., that should be undertaken by another member of staff who was identified. And as that document tells us, that on the 26th of October, John McSporran confirmed that that had been done, and that was my belief.
Right, thank you. So there had been an initial failing
Yes.
regarding omissions from
Yes.
Ms. Wise's statement, but then confirmation given by Mr. McSporran had been dealt with.
Yes.
And then can we look at 28th April 2017, the paragraph at the bottom of the page. The Commissioner advised the Crown by letter that a manual check of all the remaining statements had been completed, with each statement having been proofread and compared against the original handwritten version for accuracy. It is now clear the statement checking exercise had not been completed at the time of the Commissioner's letter. On 14th June 2017, Deputy Senior Investigator William Little advised the Crown by letter that the statement comparison process had now been completed and enclosed a disc containing 21 statements where omissions had been identified and rectified. And then it goes on to say the initial failure to provide accurate statements caused significant extra work to be carried out by the Precognosers. The amended statements required to be sent to all the expert witnesses, who were asked to confirm if anything contained within amended their opinion. None of the experts wished to amend their opinion. Statement folders previously prepared for Crown Counsel also had to be recalled to have statements removed and replaced with the correct version. I'm interested here in this apparent reassurance having been given by Mr. McSporran, the letter then from the Commissioner saying this work has been undertaken and completed, but then Mr. Little later saying it's now been completed. Were you aware of any of the circumstances surrounding this?
I don't specifically remember that, but it shouldn't have happened.
Would you agree this was a failure in terms of the PIRC investigation?
It was certainly a failure in relation to the administration of the investigation.
Thank you. Can we look at the rib fracture paragraph, which is just at the bottom of that page? So during the analysis of the statements, it was noted that 3 of the officers involved in the restraint had made reference to hearing the deceased fracturing a rib during the administration of CPR. So that was the statements provided by the officers on the 4th of June.
Okay, yes.
And a number of them spoke of hearing a fracture of a rib. It then goes on to say the deceased ribs appeared to be intact at the post-mortem on the 4th of May. However, a fracture to his left first rib was discovered following a further examination by pathologists on the 29th of May. That same day, Mr. Brown advised Anwar and Company and PIRC about the deceased's rib fracture. So we've also heard evidence from Dr. Shearer about this matter,
Okay.
that she then went in a second time to investigate this matter and discovered that there was a fractured rib.
Yes.
And that was noted on the 29th of May 2015.
Okay.
So again, that's still prior to the officer's statements having
Yes.
been obtained. And Mr. Brown, who was the head of Cap D, I believe at that time, advised the lawyers representing the family
Yes.
and PIRC about the rib fracture which had been discovered. Then in his statement dated 4th June, PC Walker told PIRC he heard the sound of a rib cracking when he was carrying out CPR. At this time, PC Walker handed over an undated pre-prepared statement to PIRC. Notably in this statement, PC Walker made no reference to hearing a rib crack during CPR. So there was an undated statement from PC Walker given to PIRC on the 4th of June,
Okay.
plus his statement to PIRC on the 4th of June. He mentions the hearing the rib fracturing on the 4th of June statement to PIRC, but there was no reference to that in his self-penned statement.
Yes.
And on the 29th of May, so 5 days prior to the 4th of June, PIRC had been advised about the rib fracture found by Dr. Shearer.
Yes.
Can we move on to the next page, please? There's reference to the other 2 officers who heard the rib fracturing, PC Payton and PC Tomlinson. And then it says the Crown carried out extensive further independent inquiries in relation to the rib fracture. It did not lead to his death, but it may have illustrated the force and mechanism of restraint used by the officers. Do you see that?
Yes, I do.
And then let's look at the final paragraph. The Precognosers found it of interest that the information about the rib fracture, which was only made known to PIRC on the 29th of May, was somehow potentially being explained away by 3 of the officers when they provided statements on the 4th of June.
Yes.
After careful consideration of all the evidence, there was insufficient evidence to make any more of it, other than to say it was suspicious and potentially called into question the integrity of the PIRC investigation at that point. Do you have any comments to make about that? Do you remember the situation arising?
I remember that there was a fractured rib found in a second examination by the doctors. I don't remember this carry on in relation to how the officers would have known that. I would have thought, and I may be wrong in reading of what's been said there, was it put to the officers during the interview process? I don't know. You know, was the fact about the broken rib put to them at interview? I don't know.
So do you think it's possible that PIRC investigators put the existence of a fractured rib to officers during the statement taking process on the 4th of June?
Well, other than that, I don't know how they would, make that comment within their statements. I don't know.
Thank you. And I think by the 4th of June, the officers we've heard had some disclosure in relation to the post-mortem findings at the post-mortem on the 4th of May.
Yes.
So they had some information about the post-mortem. Do you know the extent of the information they were given about the findings of the post-mortem?
I believe, and again this is from memory, that the only information, and I think I've made my point that I didn't think any information should have been passed previously, was that death hadn't been caused as a result of a baton strike.
As far as you're aware, was that the extent of the information given?
That was the extent of the information.
And in any event, on the 4th of May, when the post-mortem was initially carried out,
fractured rib
there was no
not known.
fracture noted. Staying on this page, please, can we look at the CCTV and timeline section? So the Crown analysed CCTV footage recovered by PIRC, and if we look at paragraph 2, although the footage is of poor quality, by contrasting with the accounts of material witnesses, airwaves messages and calls to Police Scotland, the Precognosers were able to produce a detailed timeline of events for Crown Counsel. The timeline allowed the Precognosers to pinpoint with confidence important markers in the incident, such as the arrival times of police vehicles, the duration of the restraint process, and the moment officers realised the deceased was in medical difficulty. Looking back now, do you think that is a task that PIRC investigators should have been carrying out? Collating the CCTV and the airwaves messages and such like, and preparing a more detailed timeline?
Yes, I actually thought they were. I mean, that was central to understanding what happened at the scene on that day. And they had CCTV, I'm sure they had airwaves transmission, they had statements of witnesses speaking to particular actions by the police. That should be at the core of the continuous analysis of evidence that's coming in.
So as far as you're concerned, that was a task that PIRC had carried out as part of the investigation?
Yeah, I believe that had been looked at, yes.
Thank you. Can I ask you to look at the next section, precognitions? Now, We've heard that this is a part of the Crown's process. They
Yes.
take, not statements, they're called precognitions,
Yes,
where they
absolutely,
discuss
yes.
with the witness. And 16 witnesses were identified for precognition. Precognition started at the beginning of October 2016. This is by the time they've got the PIRC report, the final, I should say, PIRC
Yes,
report.
yes.
And all except one, Sean Mullen, discussed below, was completed by the 23rd of November 2016.
Okay.
So if we can look at the next paragraph, which is now on page 8, consideration was given to whether the Crown could simply rely on the statements obtained by PIRC, but this was not considered appropriate given the nature of the decision Crown Counsel was being asked to make. The Crown were also mindful of Mr Anwar's criticism of PIRC's approach to statement taking, and particularly his observation that similar distinct phraseology was used by a number of independent witnesses. Can you tell me what this was in connection with, this concern about similar distinct phraseology?
No, that was never brought to my attention.
Right. So it may have been something Crown were aware of, but you
Yeah,
personally were not
no.
aware of any of that.
And that, by then, was certainly, by the time that my role had changed considerably.
Thank you. Can we move down, please, the page to the paragraph, although PIRC made reference in their report, there we are,
Yes.
to Sean Mullen and his passenger, Danny Robinson. It is respectfully submitted they did not fully recognise their significance. Both PIRC statements were relatively short and did not reflect the time they were at the locus. Mullen and Robinson arrived at the scene at the same time as Police Vehicle 1 and watched events unfold for a total of 1 minute 41 seconds from 4 different positions on the roadway. The precognosers did considerable work to establish Mullen and Robinson's line of sight from each position. This information was thereafter inserted into the SPA composite disc discussed below. Mullen failed to attend for precognition on a number of occasions, despite being personally served with a citation by PIRC and being spoken to personally by the precognosers. He was eventually precognosed on the 20th of December 2017. At precognition, the Crown were able to establish further important details from Mullen. In particular, he spoke to the deceased. But he spoke to the deceased attempting to kick PC short whilst she was on the ground, a fact not contained in his PIRC statement. Can I ask you if you had any concerns about the way PIRC investigated the evidence of Sean Mullen and Danny Robinson?
And again, I don't have an in-depth knowledge of that, and it was either that the correct questions weren't asked or that these witnesses decided not to provide that information at the time would be the only thing I could. So either correct questions weren't asked or they decided that they were not going to provide that information.
If it was that the correct questions hadn't been asked, would you consider that to be a failing on the
Yes.
part of the PIRC? If we can move on to Ashley Wise Snapchat, please. And it says PIRC retrieved 4 Snapchat videos from Ashley Wise's mobile telephone. We've heard evidence about these Snapchat videos. It says, although PIRC produced a detailed timeline detailing the content of each clip, they did not try to establish the timings of the clips and therefore did not recognise their significance. Would you consider, if that's correct, would you consider that to be a failing on the
Yes.
part of PIRC? By mapping the arrival times of police vehicles, the precognosers were able to establish that the first Snapchat clip occurred at some point between 7:21:47 hours and 7:22:27 hours, significant as the restraint process started at 7:21:08 hours.
Okay.
And then if we can look at the it then goes on to say, following a request by the Crown in November 2017, PIRC evidenced timings for the Snapchat clips, which were then inserted alongside the CCTV. Do you think that that is something that PIRC should have been doing prior to sending off the report to the
Yes.
Crown? Do you think that was a failing?
Yes.
Looking at the bottom of that section, the paragraph beginning identifying the timing, if if we can go to the bottom of that. Identifying the timing of the Snapchat clip 1 was an important piece of work carried out by the precognition team. It allowed a brief glimpse of the methods of restraint being used at that time. This enabled the precognosers to ask the OST expert for his opinion on the actions of the police officers at that particular time. Do you agree that a timing of the Snapchat clip 1 would have been an important piece of work for PIRC to have carried out?
Undoubtedly.
Thank you. Can we look at page 14, please? And I'm interested in the section that's called Airwave System. The precognosers carried out detailed analysis of the messages transmitted on Police Scotland's airwaves system. As stated earlier, this was principally to establish what information was available to the officers whilst en route to the locus. Following an instruction by the precognosers, PIRC also established information could not have been communicated to officers by any other means other than through the recorded channels. By comparing PIRC prepared transcripts with CCTV footage, the precognosers were able to establish a crucial message passed at 7:20:49 hours had been attributed by PIRC to the wrong officer, and that was PC Smith, as he had not yet arrived at the locus. PIRC were requested to carry out further investigations, and it was established that the message was most likely passed by PC Payton, who had pressed his emergency button at this time. Were you aware of this issue?
No.
Look, if that's correct, as described in this...
Yes, and as you quite rightly say, I mean, I think this letter's dated 2020, so these are things obviously falling out of the back end of the precognition, the majority of which I have no knowledge of.
Having looked at this now, do you agree that this is the sort of detail that PIRC should have been picking up as part of the investigation?
Yes.
And would you agree that failure to do so is a failure in the investigation?
I don't think I could say otherwise.
Could we look at page 17, please? I think there are a number of comments in this document as well, where they say that if we look towards the Kirkcaldy Police Office CCTV, and if we look at the last two paragraphs in that section, PIRC advised and the precognosers.
Yes.
PIRC confirmed they had viewed all footage contained on all 16 cameras within Kirkcaldy Police Office. That was 18 hours footage, albeit the cameras were motion sensitive and did not record unless activated.
Yep.
PIRC only produced transcripts for 5 of the cameras, as the other 11 cameras covered cells and contained nothing of evidential value. The precognosers viewed all the footage from the 5 cameras, comparing same to the transcripts prepared by PIRC. And the transcripts were found to be accurate and complete to a high standard. And the PIRC examination of the CCTV proved to be both reasonable and proportionate. So in relation to the CCTV analysis carried out by PIRC, they seem to have taken the view that that was accurate and completed to a high standard.
And would have been my expectations.
Thank you. Thank you. I have one final issue that I'd like to ask you about. Could you give me a moment? Would you be content for me to carry on, or would you prefer to...
I think you should stop for lunch now, and you can deal with that after lunch. So we'll stop for lunch and sit at 2 o'clock.